I found out from a LinkedIn post, not from my brother, not from our attorney, not even from our CFO, from a public congratulations post. Excited to step into the CEO role at Hartwell Botanicals. Grateful for the opportunity to lead us into the future. Under it, hundreds of likes. And the name at the top. Daniel Hartwell. My brother. I was sitting in a hospice chair in St. Luke's Medical Center when I saw it. My mom was asleep beside me, her breathing shallow, her skin almost translucent under the fluorescent lights. For a moment, I genuinely thought it was a mistake. Maybe interim CEO, maybe acting CEO, maybe something temporary. But no, CEO. There was no mention of me anywhere in the announcement. 9 months later, a judge in Cook County Circuit Court would look over his glasses and ask Daniel one simple question. Did your sister ever submit a written resignation? And Daniel would shift in his seat. Because the answer was no, I never resigned. I was removed. But that night in the hospice room, with machines humming and my phone screen glowing against the dark, I didn't know the paperwork had already been filed. My name is Claire Hartwell. I'm 38 years old. 10 years ago, my mom and I founded Hartwell Botanicals in her garage outside Naperville, Illinois. We made small-batch organic skincare products. Nothing fancy. Simple ingredient lists. Clean branding. No outside investors. I left a stable marketing job in Chicago to build it with her. My dad had left when I was in college. My younger brother Daniel was 19 at the time. Restless, charming, never consistent with anything. Mom and I were consistent. We reinvested every dollar for the first 3 years. I handled branding, retail contracts, operations. She developed formulations and managed production. By year 5, we had a small manufacturing facility and 23 employees. By year 7, we were stocked in over 200 Midwest retail stores. Ownership was simple. 50% mom, 50% me. Daniel was never excluded. He just never showed up. When mom was diagnosed with stage 4 pancreatic cancer, everything narrowed. The oncologist didn't sugarcoat it. We're looking at aggressive progression. I remember holding her hand and nodding like I was listening to a quarterly earnings report. I shifted into survival mode. I split my days between the facility and the hospital. Then eventually, just the hospital. Daniel started coming around more often. At first I thought it was grief. Then he started asking questions. What happens if you can't manage operations full-time? Do we have a succession plan? Who has signing authority if something happens? I answered vaguely. I was exhausted. He began spending more time at the office. Just helping out, he said. When mom's condition worsened, I stopped going in entirely. I worked remotely from the hospice room, my laptop balanced on a rolling tray next to IV bags. Daniel said he would cover day-to-day decisions. I was grateful. That was my second mistake. Mom passed away on a Tuesday morning in October. It was quiet, no dramatic final words. Just a long exhale that didn't come back. 3 days later, Daniel told me we needed to meet with the company attorney to formalize leadership continuity. I barely slept that week. At the meeting, there were documents outlining temporary operational restructuring. Just so vendors feel secure, Daniel said. You shouldn't have to deal with this right now. The attorney explained it as a short-term delegation of executive authority. I signed. I didn't read carefully. That was my third mistake. A month passed. I tried to return to the office. My key fob didn't work. I stood outside the glass doors, confused, assuming the battery had died. Our operations manager opened the door manually. You should talk to Daniel, she said quietly. My office had been rearranged. Daniel was sitting at my desk, not in my chair temporarily. In my chair like it belonged to him. Claire, he said carefully. You should have called first. What's going on? You needed time. The company needed leadership. I am leadership. He slid a folder toward me. Board resolution, filed with the Illinois Secretary of State. It stated that I had voluntarily stepped down from executive management due to emotional incapacity following our mother's death. I felt heat rise to my face. I never agreed to this. You signed the resolution. I looked at the signature. It was mine. But the wording wasn't what I remembered. I signed a temporary delegation. That's what this is. No. This says I relinquish operational control indefinitely. He shrugged slightly. You weren't in a position to make strategic decisions. There it was. The narrative. Within weeks, subtle shifts happened. Vendors addressed him as CEO. Staff meetings were scheduled without me. A company-wide email announced new leadership structure to ensure stability during transition. My name wasn't mentioned. I requested official copies of all signed documents. When they arrived, I compared them to the draft I vaguely remembered reviewing. The structure was the same, but 3 additional clauses had been inserted. Clauses stating I voluntarily relinquished executive authority and agreed not to interfere in day-to-day management. I took the documents to a corporate litigation attorney in Chicago. He read silently for a long time. Did you review this exact version before signing? No. We'll need forensic document analysis. We ordered one. At the same time, I requested updated financial statements. They were delayed. Repeatedly. When we finally received partial records, something else surfaced. A consulting agreement. Monthly payments of $38,000. Consulting firm formed 2 weeks after Mom's death. Owner, Daniel Hartwell. I drove straight to his condo. You're paying yourself nearly $40,000 a month? It's market rate for executive advisory. You appointed yourself CEO. I stepped up when you couldn't. I was grieving. Exactly. That word again. Grieving. As if grief equals incompetence. Within days, I heard from 2 longtime employees that Daniel had privately questioned my mental readiness. One even asked if I was okay to handle stress. That's when I understood the strategy. It wasn't just about control. It was about justification. The forensic report came back 6 weeks later. My signature was authentic, but the PDF metadata showed the filed document was modified at 1:47 a.m., hours after the board meeting. The inserted clauses were added from a device linked to Daniel's home IP address. I read the report twice, then I closed my laptop. That was the moment I stopped being his older sister. I became a 50% owner whose legal rights had been violated. And I hired a litigation team, because what he did wasn't family drama. It was corporate misconduct, and I was done letting grief make me small. I thought filing the lawsuit would scare him. It didn't. It escalated him. Within a week of my attorney sending a formal demand letter challenging the board resolution, Daniel's legal team responded with a petition, not just denying wrongdoing, but requesting a judicial review of my, quote, capacity to serve in an executive leadership role. I read that sentence 3 times. Capacity. They were building a case that I was emotionally unstable after our mother's death. They attached sworn statements from 2 managers claiming I appeared disoriented, overwhelmed, and unable to make clear operational decisions during the final weeks of Mom's illness. One of those managers had been promoted by Daniel 2 weeks earlier. My attorney leaned back in his chair when we reviewed the filing. This is strategic, he said. If they can cast doubt on your competence at the time you signed the resolution, they strengthen their argument. I was grieving, I said. Not incapacitated. In court, he replied calmly. They'll blur that distinction. That night, I couldn't sleep. Not because I was afraid of losing the company, but because my own brother was trying to legally define me as unstable. A week later, we filed a motion to invalidate the board resolution based on document alteration and breach of fiduciary duty. Daniel responded by moving company funds, substantial funds. Our CFO, who had worked with my mother for 7 years, quietly called me. Claire, I need you to know something. Daniel had transferred nearly $600,000 from operating reserves into what he labeled strategic restructuring expenses. Most of it was routed through his consulting firm. The timing was not subtle. My legal team immediately filed for a temporary restraining order to prevent further asset transfers. That's when things became public. Local business media picked up the story. Founder's family dispute shakes regional skincare brand. The comments online were brutal. Another family implosion. Should have had investors. This is why you don't mix family and business. I wanted to disappear. Instead, I prepared affidavits. The preliminary injunction hearing was scheduled for 3 weeks later in Cook County. In the meantime, Daniel sent a company-wide memo stating that external legal distractions might temporarily impact operations, but that leadership remains stable. Leadership. He used that word constantly now. Several longtime employees reached out privately. Some were supportive. Some were cautious. A few were clearly choosing sides. I don't blame them. When your paycheck depends on stability, you align with whoever seems in control. At the injunction hearing, the courtroom felt colder than I expected. Daniel avoided eye contact. His attorney argued that I had voluntarily stepped back and was now attempting to destabilize the company out of post-traumatic emotional distress. My attorney presented the forensic report, timestamps, version history, IP address logs. The judge listened carefully. Counsel, she said to Daniel's attorney, are you disputing that the filed version was modified after the meeting? We dispute the implication of malicious intent, not the modification. The intent. That was telling. The judge granted a temporary freeze on any further transfers from company accounts without dual authorization. It wasn't a victory, but it was oxygen. Outside the courtroom, Daniel finally spoke to me directly. You're destroying Mom's legacy? No, I said. You are. You couldn't handle it. I was handling her death. He shook his head. You were falling apart. That was when I realized something unsettling. He truly believed that, or he had convinced himself he did. The next phase was discovery. We subpoenaed internal emails, board communication logs, financial records. What surfaced was worse than I expected. Daniel had been consulting a corporate attorney 3 months before Mom died. Emails discussing leadership contingency and equity leverage. One message stood out. If Claire remains emotionally compromised, the board can act in the company's best interest. There was no board, just me and Mom, and Daniel had no equity. At the time those emails were written, he had been planning, while I was sitting in oncology waiting rooms. When my attorney showed me the email chain, something inside me settled into clarity. This wasn't opportunistic. It was premeditated. Daniel's team responded aggressively. They filed a counterclaim, alleging I had neglected executive duties during Mom's illness, causing strategic stagnation. They painted him as the savior, who stepped in to protect employees and vendor relationships. For a moment, I questioned myself. Had I missed something? Had grief made me blind? Then our operations director testified in deposition. Under oath, she stated that all major contracts during that period had been negotiated by me remotely, and that no operational deadlines were missed. Daniel's narrative started cracking, but he wasn't done. 2 months into litigation, he requested a formal psychological evaluation to determine capacity at the time of signing. My attorney objected. The judge denied the request, stating there was insufficient evidence of incapacity. I felt something like vindication for the first time. But the financial damage was real. Retail partners were nervous. One regional chain paused new purchase orders, pending leadership clarity. Cash flow tightened. Legal fees mounted. I took out a personal line of credit to cover my share of litigation costs. Daniel, meanwhile, was paying his legal team through company funds, now partially frozen. At one point, mediation was suggested. We met in a sterile conference room downtown. The mediator asked a simple question: what outcome would satisfy both parties? Daniel answered first. Full executive control with a structured buyout over 5 years, meaning I walk away slowly while he stays in charge. When it was my turn, I said, restoration of my executive authority and independent financial audit. We were not negotiating the same reality. Mediation failed. The case moved toward trial. As depositions continued, more details surfaced. Daniel had promised one manager a long-term equity incentive plan in exchange for supporting his narrative about my instability. He had instructed accounting to delay sending me financial statements until after key vendor renewals were signed under his name. The pattern was consistent. Control first, justification second. By the time trial was scheduled, the company was operating at reduced capacity. Morale was fractured. Suppliers demanded shorter payment terms. Our brand, once known for transparency, was now associated with litigation. One evening, after reviewing another stack of legal filings, I sat alone in my condo and stared at a framed photo of Mom in the garage where we first mixed product. She was smiling, sleeves rolled up, hair pulled back. We built something real. And now it was in a courtroom. That night, I stopped feeling angry. Anger is hot. What I felt instead was steady, focused. He wasn't fighting me as a sister anymore. He was fighting me as a shareholder. And in corporate law, facts matter more than emotion. The trial date was set for early spring. And for the first time since this started, I believed the truth would actually be examined, line by line, timestamp by timestamp. Daniel had underestimated one thing. Grief doesn't make you weak. Sometimes it makes you unbreakable. The trial lasted 4 days. 4 days to unpack 10 years of work, 1 year of illness, and months of calculated maneuvering. Walking into the courtroom that first morning, I felt strangely calm. Not confident. Not victorious. Just steady. Daniel sat at the opposite table in a navy suit I'd seen him wear at investor meetings years ago, back when he used to tag along but never speak. Now he was the one giving statements. The judge began by clarifying the core issues: whether the board resolution removing me from executive authority was valid, whether company funds had been improperly transferred, whether fiduciary duties had been breached. Clean. Clinical. Nothing about grief. Nothing about family. Just facts. Daniel testified first. His attorney guided him carefully. Did your sister appear emotionally capable of managing the company during your mother's final weeks? She was overwhelmed, he said. Distracted, not present. Did she voluntarily sign the resolution delegating authority to you? Yes. Did you act in what you believed was the company's best interest? Absolutely. He spoke smoothly, measured, almost rehearsed. When my attorney began cross-examination, the tone shifted. Mr. Hartwell, when did you first consult a corporate attorney regarding leadership restructuring? Daniel hesitated. Shortly before my mother passed. 3 months before, correct? Silence. Yes. And at that time, you held no ownership stake in the company? Not formally. So you were planning leadership changes before your sister had stepped away from anything? It was contingency planning. While your mother was still alive? Daniel's jaw tightened. Yes. The courtroom was quiet. Next came the forensic document specialist. She walked the judge through the metadata. Original draft timestamp, 3:12 p.m., day of meeting. Filed version timestamp, 1:47 a.m., same night. Inserted clauses highlighted side by side. And the device used for modification? my attorney asked. Registered to Mr. Hartwell's residential IP address. Daniel's attorney attempted to argue administrative correction, but there was no email notifying me of revised language, no second signature, no acknowledgement. Then came the financial records, bank transfers, consulting invoices, LLC registration documents. My attorney asked one simple question. Mr. Hartwell, did you disclose to your sister that your consulting firm would receive monthly payments of $38,000? No. Did you seek independent board approval? There was no board. Exactly. That word hung in the air. Exactly. On the third day, our former CFO testified. She confirmed that I continued approving contracts remotely during Mom's illness, that no operational deadlines were missed, that the company was financially stable before the restructuring. When Daniel's attorney suggested I had abandoned leadership responsibilities, she responded firmly, no. She was working from a hospital room. That was the first time I felt emotion rise in my throat. Not anger, recognition. On the final day, both attorneys gave closing arguments. Daniel's team framed him as a necessary stabilizer in a moment of crisis. My attorney framed it differently. This case is not about grief, he said. It is about governance. About whether one 50% owner can alter documents, transfer funds, and unilaterally assume control without lawful consent. He paused. Corporate law does not recognize emotional vulnerability as grounds for disenfranchisement. The judge recessed for 2 hours. When she returned, the courtroom stood. Her ruling was direct. The board resolution was invalid due to material alteration without informed consent. Executive authority was to be restored immediately. An independent forensic audit was ordered. The consulting payments were deemed unauthorized and subject to repayment. The matter of document alteration was referred for further review. She turned to Daniel. Fiduciary duty requires transparency and loyalty. The court finds neither sufficiently demonstrated. That was it. No dramatic gavel slam. No applause. Just consequences. Outside the courthouse, reporters waited again. This time, I gave a short statement. Our company was built on integrity. Today's ruling allows us to move forward with transparency. Daniel said nothing. In the months that followed, the audit confirmed approximately $1.2 million in improperly authorized transfers. Insurance covered part of it. Daniel negotiated a structured repayment agreement to avoid criminal charges. The company survived, but not unchanged. 2 major retail partners had already reduced shelf space. Rebuilding trust took time. We downsized from 23 employees to 18. I reinstated dual signature requirements on all transfers above $10,000. We created a formal advisory board, independent members, no family, and I removed Daniel's access to company systems entirely. We haven't spoken since the repayment agreement was finalized. Some relatives blame me. You could have handled this privately. Maybe, but privately would have meant quietly surrendering control. A year after the trial, I visited the old garage where Mom and I started everything. The house had been sold, but the new owners let me step inside for a few minutes. The concrete floor still had faint oil stains from our first mixing equipment. I stood there and remembered how scared we were at the beginning, not of failure, of dependence. That's what this was really about. Daniel believed leadership was owed to him. I believed it was earned. The hardest part wasn't the lawsuit. It wasn't the headlines. It was accepting that blood doesn't override accountability. Grief made me vulnerable, but it also made me clear. Clear about boundaries. Clear about ownership. Clear about the difference between family and fiduciary responsibility. Today, Hartwell Botanicals is stable again. Not booming. Not collapsing. Just steady, which is enough. Every time I walk into the office and my key fob unlocks the door, I don't feel triumph. I feel alignment. With the woman who mixed creams in a garage. With the daughter who sat in a hospice chair answering emails at 2 a.m. With the owner who refused to be quietly erased. Daniel once told me I was too emotional to lead. Maybe I was emotional, but I was never incompetent. And in the end, the court didn't care about emotion. It cared about evidence. That's the difference between a family argument and the truth. And the truth, line by line, held.